You found the podcast. You found the podcast, Go Beyond the Brief, where we take a deep dive into the societal currents shaping our lives. Together, we'll explore the often unseen forces at play. We'll examine the research, dissect the data, and most importantly, if you're seeking to understand what's shaping our society, this is the place.
Dive. Today, we're cracking open a story that is, well, it's a legal tectonic shift. It has the potential to completely redefine the value of a law degree in America. We're diving into a high-stakes power struggle over who gets to approve and, ultimately control legal education.
It's a huge deal.
We're talking about the unprecedented move by the Supreme Court of Texas to fully decouple from the American Bar Association's oversight of law schools.
Yeah, and this isn't just some small administrative change.
No.
This is a shot across the bow of the ABA. It really threatens its, decades-long monopoly as the national gatekeeper of the legal profession.
So our mission today is to go deep into the sources. We've got the official court documents, high-level government letters, news reports.
All the primary stuff.
Exactly. We want to explain why this break happened, what Texas is using for quality control now, and what the consequences are for you, whether you're a law student or just thinking about becoming one.
And if you are thinking about law school, you really need to listen to this. Texas is the first major state to formally say it will stop relying on the ABA for approval.
A system that's been the gold standard since, the 80s?
Pretty much. And this affects every single person attending law school in Texas or hoping to practice there. And it's not a future thing. This went into effect immediately following the final order on January 6, 2026. This is a fundamental challenge to who holds the keys to the profession.
Okay, let's unpack this. Let's start with the specifics, the what and when.
Right.
The core action is this order from the Supreme Court of Texas. It's referenced as MISPERA, docket number 26-002. And in it, they finalize an amendment to Rule 1 of their rules for admission to the bar.
And the change in wording seems subtle, but the impact is profound. It redefines what an approved law school is.
How so?
It used to say, a law school approved by the American Bar Association. Simple. Now it reads, a law school approved by the Supreme Court of Texas. In one sentence, the state's highest court just took back its authority over who trains its lawyers.
And the timeline shows this wasn't some snap decision. It was very deliberate.
Oh, absolutely. They started this process almost a year earlier. Back on April 4, 2025, they invited public comments on whether they should reduce or just completely end their reliance on the ABA.
They were testing the waters.
Exactly. Signaling a huge shift. By September 26, 2025, they are proposing the specific amendments, which, immediately became national legal news.
And then the final approval on January 6, 2026, effective immediately. So their first task must have been ensuring things didn't just fall into chaos.
That was priority number one. Stability. The biggest fear for anyone currently enrolled in a Texas law school was, what happens to my degree?
Of course.
The court managed this really carefully. The final order makes it crystal clear that the initial list of approved schools includes every school that was currently approved under the old ABA-centric rules.
So everyone was grandfathered in?
Everyone. You look at the court document and there are pages of names. Yale, Harvard, NYU, and of course Texas A&M, Texas Southern. They're all on the new Texas approved list. It guarantees that current students and recent graduates can take the Texas bar without any interruption.
Okay, so that handles stability for anyone already in the system. But the big question, the one anyone considering law school next year is asking, is about portability. For decades, ABA accreditation was basically a national passport for your law degree. How can Texas possibly guarantee that portability now that they've replaced that passport with a state-only stamp?
That is the billion-dollar question. And the court tried to answer it by creating what they call a set of simple, objective, and ideologically neutral criteria.
So they're not starting from scratch?
No, not at all. They looked at the huge ABA rulebook and just cherry-picked 4 specific standards that focus purely on professional outcomes.
Okay, wait, so they kept 4. For anyone listening, what was the strategic thinking there? Why keep, say, standards 316 and 509, but throw out dozens of others?
It's a clear move away from qualitative measures and towards, meritocracy. The standards they kept are things you can easily measure, things that show competence. Let's take Standard 316. It's probably the most important one they kept.
And what does 316 measure?
Student outcomes. Standard 316 requires that within 2 years of graduation, 75% of a law school's grads who take the bar exam have to pass it.
Simple as that.
Simple as that. If your students are passing the bar, Texas is happy. They're isolating the performance-based requirements.
So 316 is all about output. Are you producing lawyers who can actually pass the test? Okay, what about 509? That just sounds like a number.
Standard 509 is all about transparency. It forces law schools to publicly disclose critical data. Things like tuition, scholarship data, enrollment numbers, and most importantly, bar passage rates.
Ah, so you can see what you're getting into.
Precisely. By keeping 509, Texas is making sure that even under a state-only system, schools have to be upfront with you about your costs and your chances of success.
So the strategy is clear. Keep the objective stuff like bar passage and public data and get rid of the rest of the ABA's rules, which often deal with, governance, curriculum, and these ideological mandates we're about to get into.
That's it exactly. They called their new metrics no more onerous than those currently required by the ABA. And to hit that portability issue head on, the court publicly committed to preserving the portability of Texas law degrees. They also promised not to impose any extra administrative burdens on the schools.
And here's the real kicker, the ultimate Declaration of Independence. They explicitly said that a school losing its ABA accreditation will not be enough to get it removed from the Texas Proofed list.
Right, as long as it meets those 4 Texas standards.
So the ABA could, in theory, disaccredit a Texas school for some rule violation, and that school can just keep on training lawyers for the Texas bar.
It completely strips the ABA of its enforcement power in Texas. And going forward, the court says it will develop a separate approach for brand new schools that aren't ABA accredited to get on the state's list. They're creating a pathway for alternatives.
This move is powerful on its own, but it didn't happen in a vacuum, right? The sources show Texas is the first to pull the trigger, but Florida, Ohio, Tennessee,
All states with high courts composed of Republican-appointed justices.
they all launched similar reviews around the same time. There is a national trend here, and it seems to come from this growing dissatisfaction with the ABA's politics.
That is the essential context. You see officials in these states citing 2 main areas of contention. The first is all about diversity, equity, and inclusion DEI.
We have that February 2025 letter from Attorney General Pamela Bondi to the ABA, and it is remarkably direct.
It is. Bondi's letter went right after ABA Standard 206, which required law schools to, quote, demonstrate by a concrete action a commitment to diversity.
And she argued that conflicts with the big Supreme Court case from 2023.
The Students for Fair Admissions v. Harvard case, which limited using race in admissions. Her letter basically threatened that state bars might stop relying on the ABA if the council kept, in her words, abusing its privilege.
And we know from a Reuters article that Florida's review cited a similar diversity rule, so that's one side. States opposing DEI requirements. What's the other big point of contention?
The ABA's overall political activity, and this is the really surprising part, its multi-million-dollar financial relationship with the federal government.
This is where the story pivots from just academic rules to, federal political warfare.
It really is. In February 2025, the chairman of the Federal Trade Commission, Andrew Ferguson, issued a letter banning FTC political appointees from participating in ABA events.
Wow, from an entire federal agency.
Yes. He cited what he called the ABA's long history of leftist advocacy and accused them of using Democrat political talking points.
That's incredibly aggressive. What specific actions did he point to that would justify a ban like that?
The FTC letter zeroed in on a lawsuit the ABA had filed, Global Health Council versus Trump. This lawsuit challenged the Trump administration's freeze on foreign aid funding that's run by USAID and the State Department. The FTC chairman claimed the ABA's criticism was unethical because the ABA had a, quote, massive financial interest in the very policies they were fighting in court.
It's just wild to think this whole accreditation system is breaking up over issues like DEI and international aid grants. What kind of financial interest are we talking about here?
According to that FTC letter, the numbers are staggering. The ABA received over $22 million from USAID and nearly $17 million from the State Department in the 12 months before the letter was written.
Wait, so that's almost $39 million in a single year.
Almost $39 million. From the very agencies whose funding decisions they were suing the government over. The FTC called out the ABA for not disclosing this massive financial interest while actively criticizing the reform efforts.
Okay, so the ABA obviously didn't stay silent on this. They're facing accusations of partisanship, of having a massive financial conflict of interest. How did they respond?
They responded forcefully. Their defense rests on the idea that their actions, while maybe controversial, are fundamentally nonpartisan and are all about upholding legal principles.
The rule of law defense.
Exactly. In public statements from early 2025, they rejected what they called efforts to undermine the courts and the legal profession. They said they've sued or opposed policies from multiple administrations, Democrat and Republican, whenever they felt those policies interfered with access to justice.
So they see their role as a check on executive power, no matter who is in charge.
That's their position. They framed all this political backlash not as a response to their own partisanship, but as a sign of government trying to intimidate the profession.
What evidence did they point to?
They cited high-ranking officials calling for the impeachment of judges who ruled against the administration, or, attempts to target law firms that represent clients the administration doesn't like. For the ADA, this whole decoupling effort is just one part of a much larger systemic attack on the independence of the legal system itself.
And what about the money? How did they defend taking nearly $40 million from the same agencies they were suing?
They defended it as part of their global mission. The ABA president, William Bay, talked about their crucial work training lawyers and judges in other countries to build fair justice systems. He argued that this work directly helps U.S. foreign interests.
So their position is that the money supports their mission to promote the rule of law globally.
Yes, and they framed the lawsuit not as a policy dispute, but as a challenge to what they saw as an unlawful action by the executive branch to freeze funding that Congress had already approved.
So it all comes down to this core conflict. The ABA sees itself as the indispensable, nonpartisan national standard bearer. Their accreditation chief even emphasized that they're focused on ensuring a national system exists to maintain quality and, crucially, that portability for law degrees.
Right. They're framing Texas's move as a direct threat to that national standard.
Okay, so let's bring this all back. We have a major state decoupling over concerns about the ABA's politics and money, while the ABA says it's just defending the rule of law. For you, listening right now, maybe in law school or thinking about it, what does this all mean for your career?
The most important thing to know is that the immediate situation is stable. If you're currently enrolled in any ABA-accredited school, you're fine. The Texas Supreme Court really did its best to mitigate the biggest risk, which is portability.
But the risk is still there, isn't it? Even if Texas says it's not a problem.
It absolutely is. You can't ignore the warnings. 8 of Texas's 10 law school deans told the court in July 2025 that dropping the ABA requirement could seriously impede lawyer mobility.
Because it's not up to Texas.
It's not just up to Texas. The future of your Texas law degree's portability depends on whether other states, California, New York, Illinois, will accept this new Texas-only approval. If they don't recognize that Texas stamp, that law degree suddenly becomes a lot more local.
So Texas is really the test case for the whole country. If this works, if their grads can still practice everywhere,
then you can expect to see Florida, Ohio, and Tennessee follow suit very quickly. And that would completely fracture the ABA's power.
And that's the real power struggle here, isn't it?
It is. Is law school accreditation a unified national standard set by one professional body? Or is it a state function determined by a state's own judiciary and tailored to its own politics? Texas has firmly chosen that second path.
This has been an incredible deep dive. We've covered the step-by-step process the Texas Supreme Court took, the specific objective standards they're keeping, and the really powerful political drivers, the controversy over DEI and the ABA's multi-million-dollar federal contracts.
We understand the impact. Stability for now, but real uncertainty about the future of lawyer mobility if the ABA's role as the national arbiter is permanently broken by these state-level revolts.
So, a final thought for you to chew on.
The Texas Supreme Court order didn't just break ties with the ABA. It included this fascinating, forward-looking sentence. The court said it might consider, quote, returning to greater reliance on a multi-state accrediting entity other than the ABA should a suitable entity become available.
Wow.
This raises a profound question for the entire legal profession. If the traditional national accreditor is seen as too political, is the future of legal education a fractured system with 50 different state standards? Or is a new national and demonstrably non-political alternative to the ABA